Yes. Now sitting.
Thank you. Please be seated. Now I'll call the third case on this morning's docket. That is case number 109018 in the matter of the acquisition of property by eminent domain in Unified School District number 365, Anderson County, v. Donald D. Diebold and Susan H. Diebold. Did I get their names correct? Diebold, my apologies. Here we go.
Your Honors, if it would please the Court, Brett Heim enters his appearance on behalf of appellants Don and Susan Diebold. Chief Justice, I would like to reserve 5 minutes for rebuttal if necessary.
5 minutes is granted.
Thank you, Your Honor. Again, on behalf of my clients, Donald and Susan Diebold, I'd like to express my appreciation to be able to present this case to the Court. As the Court's aware, this is an appeal from an eminent domain action originating in Anderson County, Kansas. Donald and Susan Diebold were the owners of property that was taken by USD 365 for purposes of constructing a school. As this Court's aware, one of the guiding principles of eminent domain is that of equity. Individuals such as my client who have had property taken and suffered economic harm as a result, the Act is designed to govern introduction, presentation, and application of relevant data to arrive at an equitable and reasonable compensation for the parties from whom property had been taken. In this case, the Diebold's property was appraised, and they were awarded $278,800. They weren't satisfied with this award and subsequently elected to appeal that award to a jury. At the jury trial, they were given $249,000. My client's position is that based upon an order in limine that was issued prior to the trial of the matter, that their ability to present sufficient evidence in support of their particular valuation of the property, which was considerably higher than the $249,000 they were given, was compromised.
And Counsel,
yes.
If you could you describe to me how the testimony would have actually been different had the ruling not come down against you? What additional testimony would have been admitted?
Based upon my knowledge, again, I wasn't trial counsel of the case. I'm looking at this from essentially the prospect of review. My understanding is essentially Mr. Diebold would have been able to testify in greater detail about why he felt the property had appreciated so much.
His reasons, but what additional data that might have been useful in some sort of an professional appraisal process would he have added to the mix? I
believe had they interpreted the order in limine correctly, or had the order not been issued, they would have had the option of bringing in additional appraisers to support his particular position. Now, that didn't happen at trial.
How did the order in limine limit the use of outside witnesses? I thought the order in limine went only to his limitation of him as an expert.
It went to him. There was also another issue that had occurred earlier in the case that I believe may have been referenced in Mr. Deering's motion in limine, that being during depositions, Mr. Deering asked my client repeatedly, what's your basis for valuation of the property? Essentially asking what he intended to use to support his valuation. And again, for whatever reason, my client had repeatedly replied, my valuation. I'm going to provide the value. And Mr. Deering appropriately asked at that point, any other information you're going to offer? And essentially, my client stuck with the same answer again and again. It will be my valuation. It will be my valuation. And it's that answer and the orders that have resulted therefrom that put him in the position where essentially, and I believe Mr. Tetweiler's included this item in his particular brief, where that deposition exhibit number 1 would have been extremely important to my client.
So the evidence you would have admitted would have been going through the detail of each line of deposition exhibit 1 and saying there was this work done, the expense of that was X?
Yes. Now, I think my client can testify, my position would be my client could testify as to the expenditure he made. Now, I don't know that he can testify to the particular contents of either of those items or how the conclusions in those items were particularly arrived at, but I think he could have very easily stated, I spent this on the property.
Why is it relevant what someone spends on year-to-year operating expenses?
I would consider it relevant, Your Honor, based on the fact that that is one of the factors that he utilized in coming up with this value.
But his valuation method didn't match any of the statutorily provided valuation methods, did it?
I would say on its face, no, Your Honor, but however, in looking at, let me access my notes very quickly. In the Creason case, essentially, and this goes back to, I believe, quoting Eisnering, if I can just access my notes here in a moment. I don't believe there was necessarily a way to get a comparable sales valuation on the property, and I don't know that there is any way, based upon the evidence that's in the record, that there would have necessarily been any kind of basis for cost or for capitalization of income.
Well, let's don't focus on statutory methods. Let's focus on reality. What difference does it make that your client spent money on interest on a purchase money mortgage? Why is land more valuable if you borrow the money to buy it than if you pay cash? And that's what he's saying, is because I had to borrow the money, my land's worth more than if I had paid cash. That just doesn't make sense.
I think what he's trying to say, and what he would have liked to present to the court, was the fact that I've come up with this valuation, $462,000. Now, absent anything but his statement, that number appears completely arbitrary.
But he can opine on the value of his own property, but that opinion has to be based on relevant facts. And he couldn't say, I need a bunch of money because I have 2 kids in college, so that's why my land's worth more money. You would agree that that wouldn't be admissible?
I would agree.
If the interest you pay on a mortgage to buy is no more relevant than the fact you have kids in college, why could he say that? Well, the whole purpose is not to inundate the jury with extraneous information that doesn't impact their decision. And since that most of the items on this list were not relevant to the willing buyer would pay to a willing seller, why could he say it?
I would agree some of those, in all likelihood, would not be relevant. There were some that I would argue perhaps were.
Which ones? Which one on the, I've got the exhibit up in front of me, and we're talking about attorney fees, we're talking the property tax he paid for 4 years, attorney fees again, and his return on investment. We've already said that the profits you make on a business on property are not a legitimate part of eminent domain. So what on this list would be relevant to the fair market value of the property?
My position would be that we would start with the topographical site plan and survey, the site plan,
Now, let me stop you as you go through this.
Yes.
Could you please also identify, wasn't he allowed to testify that he had those things done?
I think he was allowed to testify that those were done, but was not allowed to necessarily testify as to the value of those or how those particular items factored into his value on the proposed land.
So he was not allowed to bring in hearsay?
I don't think it's hearsay that I think he can say very clearly what he paid for those. And I think he can
So
testify.
you're not saying the content, you're saying the cost of that?
I'm saying the cost, and I'm saying that I think he can, I would believe he could testify as far as what his belief is and how those particular items impacted the value of the property. In other words, he may not be able to say what the site survey said, but I think he can certainly demonstrate or state to the jury what actions he took or what value he placed upon that particular item.
Did the court really limit that?
I believe in looking at his testimony, it did, and that's one of the issues as far as the order in limine. It appears to me that it was very difficult for trial counsel to necessarily agree or understand on what the scope of that was.
And is that a problem with the trial counsel not making the appropriate record, that we're even having to ask these questions?
That is a point of concern, Your Honor, yes.
Okay, I return to what you were doing with Justice Johnson, going through the list. Sorry.
But essentially, Your Honors, you've hit on, you've brought us to...
I want to follow up.
Yes.
You indicated that the site plan and survey, that we have two items there, would impact, and I need an explanation. The day before the site plan and survey were done, if I were willing to pay X amount, the day after it was done, why would I be willing to pay $12,000 more?
My client's position would be that he had purchased the land for a specific purpose. And these particular steps, the site plan, the topographical analysis...
I understand that he made the investment and that he didn't get to use it for what he wanted to do, but that's not what the issue for the jury here was. What is a theoretical willing buyer willing to pay a willing seller for this property? And I don't understand why doing preparatory work to make use of it himself increase the value of the property for someone else. The school, for instance, they wouldn't care about any site survey that was done with regard to the expansion of a lumber yard that he was going to do. If I were to buy it for farm ground, I wouldn't care. So, I mean, why would that impact what I would pay for that land?
The way it would impact is essentially as our client presents his version of what the valuation of the property is, which is one element that would be considered. That explains why his valuation is so much higher than that by the appraisers, that was submitted in this particular case.
So is it your position that a landowner can use any testimony they want to without any rein by the trial court?
No.
As long as it's how the landowner values their property?
I think I would be very, very careful on how I presented that evidence. I think he can state, this is what I had done. This is what I paid for it. This is how I feel this enhanced the value of my property. I think absent any other witnesses, or absent, for example, the individuals who performed the topographical site analysis, essentially absent any hearsay, I think he can present that.
Is the issue relevance? And if so, doesn't the trial court have the discretion, and how do we overrule that discretion on appeal?
Essentially, as far as relevance, I think that information is relevant. It's relevant to his part of that equation of value. It's relevant to his perspective on what he felt that property was valued as at the time of the taking. The jury would then weigh on whether or not his valuation was credible or appropriate. I believe that the case law clearly establishes a landowner can testify as to what they perceive the value of their land to be. And our position in this case is simply that he was allowed to state a value, but wasn't necessarily allowed to flesh out why within the realm of what would have been admissible and would have been appropriate.
And is our test then that no reasonable person would have agreed with the trial judge's ruling? Or is there some other type of abuse of discretion that you're arguing?
As I frame the appeal, we looked at this. I looked at this in two ways. I think certainly abuse of discretion applies. The other position that we've placed before the court is that perhaps, based on the court's reliance on the Manhattan Ice case, that perhaps the judge looking at that particular case and using that as part of his opinion would perhaps push this appeal into the realm of question of law and perhaps be de novo. If it is not, then yes, we're looking at an abuse of discretion standard, and yes, the reasonable test that you've put forth would apply.
Is the question, did the judge abuse his discretion in the order itself or how it's applied?
I think the abuse in this particular case, based upon the history going back to the deposition phase, was probably in the application. That's where I feel it occurred.
So is that preserved in the record?
That's a point of concern. I believe it is in the sense that Mr. Apt did try to proffer some of that evidence to the court. I mean, I think the court was very well aware of the content of that evidence. I think it was aware of the intended use. And I think Judge Goddard's comments in the motions hearing tend to support that he was aware of that. I believe the situation was both Mr. Deering and Mr. Apt had left the hearing on the motion in limine with two very different ideas of what would be presented. And we ran into that the day of trial.
Counsel, I see you're out of time. Would you like 30 seconds to summarize?
I'll take care of that on rebuttal, Your Honor.
Any further questions? Thank you, counsel.
If it please the court, Lee Tetweiler representing USD 365. Neither of the attorneys that appear before you here today were the trial attorneys in this case. That's kind of a unique situation. I know I've never been in that exact situation, so I kind of look at it the same way you're looking at it, I guess. You have to look at the record. The two of us got here through different means, though. I got here because the school district's longtime attorney, my good friend Steve Deering, passed away, and this was one of the cases that I had taken over for him on his behalf. Driving down this morning, I couldn't help but think about him and this case, and that the sum total of his cross-examination consists of 4 pages in the record and 1 further page of recross. Now, I've got 15 minutes here this morning, and I don't know whether it would be in honor of his memory that I would take less time than that, or it would be dishonorable to take more time than that. But I can sum up this case as he did in his last question on cross-examination when he asked Mr. Diebel, do you have any evidence to support your testimony that your belief, your opinion is $432,000? No. Thank you. And he sat down. And that was it.
Couldn't you argue, though, that the survey that we spoke of earlier, the topographical survey, is relevant to a certain degree? I mean, if you buy property that includes a completed survey and you intend on using that property consistent with what is included in that survey, wouldn't that somehow be relevant to the value of the property?
Yes, of course. And Judge Goddard specifically said it would be admissible with Schaefer Klein and the other professionals' GBILP foundation testimony.
But the cost of that wouldn't be relevant?
Absolutely not. How did the cost make it more valuable the day after they did it? I mean, he wants his attorney. He wants his attorney.
Just the existence of the survey. Yep. And if a eventual buyer is interested in that survey, doesn't have to complete it, doesn't have to spend the $12,000. Isn't that, I mean, I'm just asking, isn't that relevant to the value of the property in some way?
I think it is relevant, but it has to be admissible, and Mr. Diebel couldn't testify to that. The judge specifically said what he could testify. No one's saying he can't testify. He did testify. His value is $432,000. No one's saying he did testify. What was the purchase price? $250. When did you buy it? In November of '06. What was the purpose for his new lumber yard? He didn't restrict his layman testimony. Landowners in Kansas can testify to all that, and he did so.
And why can't they explain why they reach the number they do, regardless of the basis for that? Because we have not, the case law really hasn't restricted it. It hasn't said.
Well, there's only three appraisal methods that I'm aware of that we have to comply with.
Landowner required to use an appraisal method.
I guess you're going to tell us. I've always thought so, because he's not an expert.
No, that's the point, isn't it? That I arrive at the value of my property by whatever I do just because I am a landowner and have a knowledge of the property and some ability to form my own opinion about what I would think a reasonable buyer might pay.
And his opinion and his belief was admissible, and he so testified. But to go beyond there, you get into all the evidentiary rules that he didn't want to comply with, and he didn't comply with. He could have had Schaefer Klein's man or woman come down and testify briefly, foundation, in it goes. He chose not to. He could have had the other surveyor people come down and testify. He chose not to. He could have objected before trial. He chose not to. He could have made a proffer. He could have appealed. He didn't do any of those things. We have one witness and no exhibits.
But you still have to advise the jury the basis upon which they are to determine the fair market value, because it's their decision to make.
And they have
And
to-
if you have a landowner that says, I think it's worth $500,000 because I have a pretty face, or because I spend a lot on property taxes, if those aren't appropriate considerations to find the issue the jury has to find, then either it has to be excluded or the district judge has to instruct the jury that you can't consider that as part of the fair market value calculus. Isn't that what has to happen? I mean, I don't
Under the
understand.
rules of evidence, I don't think so. I mean, a landowner can say whatever he wants, but then the jury determines the credibility of that landowner's testimony. Is it his good looks?
But
Is it the interest
he
that he
can't
paid?
testify as to a matter of law. And the factors that are used to find fair market value are contained in the statute, and that's a legal question. And so the district court has to be a gatekeeper on what the jury is told about the legal issues, which would include the factors that are appropriate to determine fair market value, regardless of who's testifying.
I agree, and he couldn't do that under the statutory requirements. He didn't have any comparable sales. He had no cost analysis. He's not an accountant. He's not a realtor. He's not an appraiser. He's a landowner, and he told the jury what he thought his property was worth, and apparently they didn't believe him. But he wants more money, and so here we are. I mean, we paid in. He's taken the money out. We've built the building. The kids are in the school, and here we are today. It took us over a year. He didn't file a notice of appeal timely. I filed a motion to dismiss. It took him 6 months from June to December to file a motion to dock it out of time. Then there was no bond, and then the judge ended up letting him post a paper bond. I mean, even if we win, I don't know for sure if we're going to get our money back, because he's got our $28,900 that we paid in that he took out, took an appeal to get more, and got less. So here we are. But again, I thought I'd make a really short presentation in honor of Mr. Deering's precise cross-examination, but I'll be happy to. I don't want to just argue about it. It seems very clear to me. I think because of counsel's candid answers to your questions this morning, I think it's clear to him too. But here we are. I'd be happy to answer any other questions.
Any more questions of counsel? Thank you.
Thank you.
You reserve 5 minutes for rebuttal.
Your Honors, again, Mr. Tetweiler and I think we're in agreement that this is a very narrow, very simple case at this point. I think the court has properly focused its inquiry here. In this particular matter, the jury was the party, the body that decided the value. And when my client was allowed to present his information to the jury, he wasn't allowed to present information to substantiate his claims of value. And in so doing, I think the potential impact of that value is very, very diminished to the jury.
But even if we would agree with you and say that that evidence should have come in, how could we say that it would have affected the verdict when the inquiry that the jury would have been focused on was what a reasonable buyer and seller would have come to agreement on?
We don't know that it would or that it wouldn't have. That's the point. That's the point of contention, at least from our perspective, is that we don't know what the jury would have said. Perhaps the jury would have offered more. Perhaps they would have offered less. Should this matter be remanded to the trial court for a new trial? My clients may receive less than they did this last time around.
We have to be able to say there's a reasonable probability of a different verdict before we can say this error wasn't harmless.
In this particular case, where the valuation is such an intrinsic part of this case, and my client's side of that was so necessary to proper computation of value, I think, yes, you still have to answer that inquiry, but I think we really have to look very closely at the potential impact of my client's inability to offer his entire story, for lack of a better term, to that determination.
The jury verdict fell within the range that was offered by everybody in the case, though, didn't it?
Yes, it did.
It was on the high end of the appraiser for the school district. wasn't
Yes.
it? Yeah, it was at the very high end. I'm wondering if we aren't struggling over the difference between materiality and probativity, the two aspects of relevance.
Yes.
I think I'm following you. I think you're making a probativity argument. You're saying that the evidence your client wanted to present, whether it was the document or his testimony about the document, was probative about his opinion.
Yes.
Helpful to understanding his opinion. But I think what the rest of us may be struggling with is the idea about materiality. Is it really material when the only issue, it's not just that this case is primarily about value, it is only about value.
Right.
We're not here for anything else. You're not here for anything else. Your opponent's not. It's all about fair market value. The jury was only to decide that one issue. And I just am struggling to see how anything your client may have added would have been material. May have been probative. It may have helped him to explain why he got to the number he got to. But I don't know that it's material. Because none of those things that are listed on that exhibit that you say are really kind of the focus
Right.
have anything to do with any of the valuation methods that the jury was compelled to apply in order to arrive at a result.
I would argue that when this case, we don't have the usual means of determining market value. I think it's a little more ambiguous in this case due to the nature of the property, the lack of comparable sales, et cetera. But when the usual means of ascertaining market value are lacking or aren't present, the necessity of the case is then to look at to determine the proper market value by looking at the intrinsic value of the property, looking at its value to the owners for special purposes, and under those particular circumstances, I think that this information would be material. I think that those surveys were done for a specific purpose. I think in my client's mind that certainly enhanced his perception of the value of the property.
And how do we draw the line between determining what should have gone to the jury and what we allow to be worked over on cross-examination?
I think in this, I think basically we follow the rules of evidence. I think anything short of crossing the line in this particular, in a situation like this where a landowner is testifying, should be permitted.
So if a landowner came in and said, this property is worth $500,000 because I have a handsome face, you think that is admissible as evidence, and it's for opposing counsel to bring out on cross-examination that really is not an important value consideration, and therefore it's up to the jury to determine whether that is important?
I think that in this particular case, parties make comments of that nature at their peril, but such comments are subject to cross-examination. They are subject to an analysis of weight and weight and credibility by the jury.
And if opposing counsel had filed a motion in limine saying there's no way this can be going to the jury, whether it's probative or whether it's material, you think that motion would be denied, and basically everything's fair game as long as the landowner says this is what I think the value of my property is?
I would say to err on the side of caution, yes. I would rather the jury have too much information than the jury not have enough. And when the jury makes that valuation decision, that they do it knowing not just the numbers from both sides, but the bases for those numbers, the reasons those numbers have been generated, where they originate. And again, should the basis be outlandish, I have faith that a jury would certainly take that into account and give those dollar figures weight accordingly.
But we're not writing on a clean slate. We have a legislative enactment. We have a whole set of the Kansas statutes that deal with eminent domain and a subset that deal with valuation. And it specifically says what can be considered when determining the valuation. And so you're saying that you can violate that statute and offer factors to the jury that aren't legally appropriate factors, and then just let them sort it out?
No, I don't think this particular course of action violates the statute at all. I think when it's restricted to the landowner's testimony, which case law clearly indicates he or she can offer. And I think when it's within the borders of that particular submission and that particular evidence type, I think the owner should be free to say why they think it's worth a certain amount.
But don't you think the jury needs to be informed as to which factors are legally appropriate to consider?
Yes.
Any further presentation?
No, Your Honors.
Do you have any more questions? Thank you, counsel.
Thank you.
We thank you both for your arguments this morning. Court will take this matter under advisement.